Here, Denias, file 23187.
Okay, we're here for a couple of different things today, a pretrial on a father's case and a mother's initial disposition. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. McVeigh.
Megan McVeigh from the department, and I also have the foster care worker here.
Macy Moore from Catholic Charities.
Okay, will you spell that for us, please?
MACYMOORE.
Thank you.
Michael Brooks, I represent the putative legal father, Jacob Bliss. Mr. Bliss.
I'm Jacob Bliss. Michael McFarland, representing mother. Please introduce yourself to the court.
Cheyenne Denias.
Thank you so much. All right, well, we can take the pretrial first. I would note, I don't have a proposed case services plan or any kind of initial report as it relates to mom's dispo, so.
I did do those this morning. I have a signed case service plan and then also a couple copies of a court report. I just didn't have time to send it out with it being so close together.
Were you able to meet with the mother about the case services?
Just the case service plan. We met at 1 o'clock right before this started, but this was the first time we could meet.
So we'll see what we might want to do about that in a few minutes. Let's tackle the father's case first. Ms. Thomas, any comments on this?
Your Honor, I believe that at the last hearing, at the preliminary hearing, Mr. Brooks represented that his client would, I believe, essentially like to release his parental rights. But given that we do have a parent who we would still be looking for reunification, that process looks a little different. And I don't know what Mr. Brooks' position or his client's position is on that, but we are willing to explore that a little more. But I don't know that we've done or gotten any information about a potential biological father.
Since that time, I got a call this morning from my client who said he has changed his mind and he wants a DNA test because he says he is not the bio dad. In fact, this lady was pregnant for 2 months before they got together even. And he just says he wants a DNA test, which apparently was ordered in Jackson County by the probate judge over there. And here is an order I was just handed regarding motion to remove name from birth certificate. Well, I don't think he was ever on the birth certificate, but he is on an AOP, which has been filed with the state. But he is asking that he be given and be allowed to take a DNA test along with the child. I'm, if I may, Dave, would you show this to the judge?
Any objection?
No.
Thank you, sir.
Ms. Thomas, any objection to me having a look at this? I don't know if you've seen it.
I have not.
Doubt she has.
Yeah, I don't know that Lee and I have. And I believe you said it was just a motion, Mr. Brooks.
It's an order from case file number 19-2090DS concerning Cheyenne Denias versus Jacob Bliss, issued by Judge Rapley out of Jackson. I'd be happy to read it to you if you want.
No, that's okay. I'll look
Something
at
like
it later.
that, or summarize it, and then I would pass my objection.
All
It
right.
orders a DNA test.
It's titled Order After Hearing Regarding a Motion to Remove Name from Birth Certificate. A hearing was held on March 12, 2020 regarding a motion to remove name from birth certificate, at which time both plaintiff and defendant appeared in person. For reasons stated on the record, it is hereby ordered that the minor child shall have a DNA test within the next 30 days to determine whether the defendant is the biological father. It is further ordered defendant shall pay all expenses related to the DNA testing of the minor child. It is further ordered all prior orders not in conflict remain in full force and effect, executed March 12, 2020.
Well, truthfully, I don't know why they bother with the birth certificate since that's not evidence of paternity anyway.
Well said, but I think that point remains that you would like cooperation in a DNA test.
Right.
All right, your position on that, Ms. Thomas?
I just, point of clarification, I'm sorry, and that order, who was the defendant?
Jacob Bliss.
Okay, and so Mr. Bliss is going to remain responsible for paying for the DNA? We're asking essentially for that order to be enforced?
Yes.
Okay,
I believe if
Okay,
you
as
ask,
in you have no objection, or okay, as in?
right, yes, my okay was to the no objection. Sorry about that, Judge.
I
Okay.
believe if you ask the mother under oath, she's going to agree that that is the circumstances. He is not the father.
Well, I'd like to hear from Ms. Heiss on this, because obviously this changes the trajectory of our case.
Yes, Your Honor, thank you. I don't object to that being offered as evidence. However, the DNA test, was it performed then within 30 days of that order? I take it wasn't. But
No,
so I don't know what the barrier was at that time, but a DNA test that shows him to not be the biological father only goes so far. When we find the biological father, there may be a motion under the Paternity Act to relieve this person, the legal father, of his legal obligations. But as the child's representative, even a non-biological child can be held to the legal duties of a father, and I would not want to leave this child fatherless. So I think all that work needs to be done. If he, I think, was going to set his case for trial, if he can give us longer to explore all this. I don't disagree with the legal father's point of view, but there are steps that we have to take, and just a DNA test isn't going to win the day necessarily. Was that a divorce case or custody case, or just that motion standalone in Jackson? So other questions that I want to get answered.
Well, it appears to be a DS case code, which would indicate, to me at least, that there may have been a support action instituted at some point.
Okay.
Is your client paying child support, Mr. Brooks?
he is not.
Ms. McVeigh, in your research ahead of the filing of the petition in this case, did you find that such a case was determinative on the issue of paternity? I'm not seeing the addendum that discusses all other cases, and maybe I'm just missing it. But did you do a search to see if there were any other cases concerning this child?
Yes.
Did you find this one?
No, I did not. I must have missed it since it was in Jackson County and not Runaway County.
I have the AOP number if it helps the court.
It does. I have in my notes and I'm still missing that.
AOP number is 20-190-158-18.
All right, Mr. Brooks, does your client have any idea who the father would be if it isn't him?
He says he does.
And the name?
Terry Andrew Donnelly.
Do you have any idea how to spell it?
Terry, Andrew, Andrew, Donnelly, Donnelly.
Do you know anything else about this person?
No, but he does live in Jackson. It's not hard to find. I know a lot of people in Jackson. I mean, I know it's not required to find it, but I know he lives in Jackson.
I made contact with Mr. Donnelly.
All right, let's let Ms. Thomas run the show here for a minute. Deputy, would you swear in Ms. McVeigh? Back to the
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms. Thomas?
Thank you. Ms. McVeigh, since our hearing on October 20th, have you had the opportunity to speak to either respondent parent about the potential genetic biological father of the child?
Yes, I actually made contact with him prior to filing the petition. He through Facebook Messenger. And he says he is, Mr. Terry Donnelly said that he is potentially the father. But he's not sure.
Okay, and did you ask if he was interested in establishing paternity?
He said he's interested in participating in a DNA test.
And is that something that the department can assist in doing, or is there a barrier given if there's a legal father?
There's a barrier due to having a legal father.
And if the department was to assist in paying for Mr. Donnelly's DNA test, would that have to be part of a court order?
Yes, it needs to be part of the court order.
And other than Mr. Donnelly, Nias or Mr. Bliss indicated any other person that may be the biological father?
Not at this time.
Thank you so much, Ms. Your Honor, I have no further questions.
Okay, Ms. Thomas, just so you know, your mic is kind of cutting out here and there. We're getting it clear, but it's just dropping here and there. So I just wanted to bring that to your attention.
Thank you, Judge.
Questions, Mr. Brooks?
I have none.
Mr. McFarland?
No, Your Honor. I would like to call my client on this issue at some time.
All right, Ms. Heiss?
Just one question. Ms. McVeigh, do you know if the mother has been married at any time?
She has not been married.
Thank you. Thank you. Nothing for.
All right. All right, I would be inclined to grant in order to allow the exploration of DNA testing for your client, Mr. Brooks, as well as for Mr. Donnelly. But before I relieve him of his legal obligations to the child, I would like to see the results of those tests.
Makes sense to me.
So what I would be willing to do for you is to adjourn your pretrial to be heard at a later time. And I can do that at our next review, or I can try to set it for a time before that. What would be your preference?
Well, I don't pretend to know how much of a waiting list there is to do DNA exams, but depending on what that is will determine my answer as quickly as possible. I get the impression my client and his family want this testing done as quickly as possible, which means my client's got to be tested and the child has to be tested, as I understand it.
Ms. McVeigh, have you done any DNA testing lately to have a, oh, we've got another volunteer for potentially a little more information.
Just on the DNA issue.
All right, come on up to the podium and give us your name, please. Sure.
Kristen Smith, foster care worker, Catholic Charities. I'm here with Macy Moore. But regarding this issue, I've actually done a lot of DNA testing at our office. We reach out to the agency, they send the kits, we do the swabs and then send them back. And we've gotten results back in like less than a week. So I would at least ask for a month just to be safe, but I think that we could get the DNA test completed and back within 30.
Well, I'm sure I could get my client there today, but I don't know about the baby.
We don't have a kit today. I have to reach out to the department first that does it and they mail the kit.
Okay. All right, does anybody have any questions for Ms. Smith that we should keep her at the microphone?
No.
I have one question. So Ms. Smith, the procedure that you're.
Do we need to swear her in?
Just let's see what her question is if we're going to keep going.
Sure.
I was just going to ask, because typically when we get the DNA test back, we have a photo of the child, the photo of the alleged parent, all of those things. Is that the same process that the test you're speaking of provides?
Yes.
Okay, thank you. No further questions.
Thank you, Ms. Smith. Suppose the next question is, actually speaking, do we have time for a pretrial in your case? Given the holidays, so let me look.
Judge, I know that we are set for a bench trial in this case on 11/28. I don't know if we could maybe turn that into a pretrial. I don't know if it does. Yeah, I don't know if it does good with whether DNA will be back, but you can hope.
Any objections?
No, Your Honor.
No objection.
My client will not have to appear, correct, Your Honor?
Yes.
And we take no position.
Very good. So we will conduct the pretrial then on November 28th at 2:30 p.m.
November 28th at 2:30.
And in the meantime, the pretrial order will reflect that the department is asked to conduct DNA testing for Mr. Bliss as well as for Mr. Donnelly and the child. Okay? Yes. Very good. All right, Mr. Brooks, are you going to continue with us this afternoon, or?
I have a 2:30.
So any objection to Mr. Brooks's request to be released for the day then?
No.
No
Oh, Your Honor,
objection.
I was gonna ask his client one question, so I was intending on calling him for one question.
What was your question?
I was gonna be that he met my client after she was already 2 months with child. So they had no, the court wants that for another day, we can do that.
Yes, I would prefer that if you don't mind.
That'd be
I
perfectly
think
fine
our
now.
DNA test will answer the questions for us.
Okay, sure.
All right, so Mr. Bliss, you're welcome to stay if you like, or you're excused for today. We've dealt with the aspects of your case. You will be required to participate in that DNA as well as to rejoin us November 28th at 2:30. Any questions? Okay, thank you for coming in.
Thank you, Your Honor. There you go, Mike.
Yep.
All right, Ms. Thomas, as it relates to mother's initial disposition.
Your Honor, given that we did not have proper of the court report or the case service plan.
Okay, hang on, and it might just be us in the courtroom, but actually your microphone is worse.
Sorry, Judge, I'm going to try to close out of some programs to see if that will help. Is it coming off bad still?
Not as bad as it was.
Judge, given that I don't have a court report or the case service plan, I understand that it was just a 10-day turnaround. I'm making it very hard for that to be done promptly. I would ask for a quick recess so that it could be emailed to me. But otherwise, I would ask for an adjournment if we're not agreeable to a recess.
I do have some time, a week from today. There must have been a jury trial that is now not happening. If that works for everyone. I also have some time, a pocket of time on Thursday morning, November 2nd at 9.
Your Honor, my client has reviewed it. I've discussed that with her. She has no objections to being ordered into the case service plan. If that sways anybody's opinion.
Do you have an issue with reviewing the court report that was prepared for today?
Well, I don't have the court report, Your Honor, so.
None of us do. I think it's the problem.
Right, so. I hate to have dead time when my client could be given credit for advancing. I don't mind adjourning and me doing the court report another time.
Well, are you available Thursday morning at 9?
I am.
Is everyone else available
Are you available?
Thursday at 9?
Yes. Yes.
Ms. Heiss, would you prefer that we conducted it Thursday at 9?
Yes. I would also use that opportunity to meet with the child, which I have not done.
Okay.
Yeah, we don't need to adopt the case service plan today if it's Thursday, Your Honor. So.
Great. All right. Well, then I will grant the request for adjournment by Ms. Thomas, and we'll conduct our initial disposition Thursday at 9 a.m. That will give Ms. Heiss hopefully some time to meet with the child and all of us some time to look at the court report. Thank you for preparing one, and we'll go from there on Thursday at 9. All other prior orders remaining in full force and effect.